On the record in the matter of the people of the state of Michigan versus Noel Jackson. File number 23-00617. Mr. Jackson, you need an interpreter?
Yes.
Okay. You were supposed to be in court yesterday.
Yes.
What happened?
Yesterday I was in emergency.
Emergency? The hospital?
Yes, that's why I did not make it.
Okay. Do we have an interpreter yesterday? I don't remember seeing him. Okay. We'll get you a new date.
August 7th at 10:30.
August 7th at 10:30 is your new date, okay?
You want to be on the phone?
I'm sorry?
You want to be on the phone?
It could be Zoom or you can come in person, either way, okay?
But I work in the morning shift. I'd like to be in the Zoom at 2:30,
At 10:30?
not 2.
No, you don't get to pick times. That's not how it works.
Oh, I'm sorry.
Yeah, you gotta do it when the prosecutor's here. He'll be here in the morning,
Thank you.
okay?
Thank you.
No problem. You're all set.
Thank you.
Yeah, oh, he wasn't on my doctor's, that's why. Huh?
He was.
Did we have an interpreter in this one? I don't remember. Either way, Mr. Smith is in the waiting room. Okay, we're on the record in the matter of LAFQ versus Lenitra Middlebrook, file number 15-01722 GC. Counsel, can I have your appearance?
For plaintiff LAFQ, Tim Smith, P48259.
Okay, and Ms. Middlebrook is present in the courtroom,
Yes, ma'am.
and today is the date and the time set for show cause after bench warrant. Let's see. Okay, looks like there was a hearing set for you back in August 1st, 2022. You did previously meet with Mr. Smith, though, correct?
Mhm.
Is that, you have to say yes or no for the
Oh,
record?
yes.
Okay, and I don't know, was it documents that were supposed to be provided, Mr. Smith?
It looks like, Your Honor, there originally was there were documents that were to be provided. There was a failure to appear. I thought it looks like a show cause in 22 August when she failed to appear.
Correct. Correct. Okay, so she was arraigned on that back on June 21st, and she provided the court with a new updated address. She's no longer at the address previously on the court file, which is why she missed her court date. Did you need to meet with her privately today?
Yes, Your Honor.
Okay, we'll get her on Zoom and you can discuss your matters privately. Let's see, do you have a device with you?
Mhm.
We can get on Zoom, otherwise when he comes back, I can get him on the court iPad.
Okay.
Can you get her on Zoom in a private room so she can meet with Mr. Smith?
Thank you, Your Honor.
Thank you.
Thank you.
Thank you. Okay. I'll put this one here while I wait. Mr. Cates never came back. What happened to that? His fingerprints will not.
Oh, that was the one that's supposed to show up. Okay.
Because he didn't want to get his fingerprints done. He said he didn't have a ride when he was sitting in the car with his girlfriend. So we'll see about that. On the record, in the matter of PCA acquisitions versus Jeffrey Kinney.
Good afternoon, Your Honor. Michael Bickstein, P 69778 on behalf of PCA Acquisitions.
I don't see Jeffrey Kinney.
If you want to give him a little more time to show up, that's okay with me, Your Honor.
Train control completed. Let's see, no response received. Plaintiff's brief, defendant's response. I'm not inclined to give him additional time. He's got a court date to be here. He's supposed to be here. Just want to make sure he's not in the hallway. I'll have my court officer double check. Let's see. Okay. Room 1. Miss Middlebrook, I'm gonna put you in room 1. And
Okay.
Mr. Smith, 1. Okay, we'll go off the record and I'll have someone check to see if he is here. Mr. Bigelow, is there anyone in the hallway?
Mr. Vitale's here, but his attorney is speaking with the PDs in
Okay,
the other
so
conference room. That's it.
no Jeffrey Kinney?
No.
Okay. Counsel, how did you want to proceed?
Your Honor, if defendant isn't present and if the court doesn't want to give him more time to appear, then I'm asking the court to grant our motion for the reasons set forth in the brief. And I believe we had a reply brief also, Your Honor.
I do see both your brief and your reply brief that defendant failed to appear. This matter was scheduled for 2 p.m. It's currently 2:23, but no one is on the virtual courtroom or in the physical courtroom on the behalf of Mr. Jeffrey Kinney. Judgment will be entered in favor of the plaintiff for the reasons argued in their motion and brief. Did you submit a order?
We have a proposed order. It's about 3 pages in from the back, Your Honor.
On the original or the response? Let me see.
On the motion for summary disposition, Your Honor. For some reason, like clockwork, and it's about 2 or 3 pages in from the back every time.
Oh, I think I see it.
I think that's just kind of where it ends up when the whole thing gets kind of packaged and processed and shipped over.
Makes sense. So I will sign and date that granting judgment against the defendant, Mr. Kinney, in the amount of $8,277.41 plus court costs in the amount of $151.19 and statutory attorney fee of $75 for a total of $8,503.60. That'll be signed and dated for today. Any
Thank you, Your Honor.
additional matters? You're welcome.
I have nothing further. Thank you very much, Your Honor. Have a great day.
Same to you. Let's see. On the record, in the matter.
Sally's attorney is speaking with the P's and whatever.
Okay, sounds good. On the record, in the matter of Stanley Meyer versus Alejandro Arambula and Ana Gonzalez Arambula, file numbers 23-00618 SP. Council appearance.
Good afternoon, Your Honor. Sean Mock on behalf of plaintiff Stanley Meyer.
Okay, I see Miss Victoria Arambula. If you can unmute and state your name for the record.
Hello, Victoria Rambula.
And then Alejandro as well, if you can unmute and state your name.
Alejandro Arambula.
Okay, today was the date set for a motion to set aside. I'm not sure what it says on the thing, but is the motion to set aside judgment and for new trial?
That is correct, Your Honor.
Okay, based on what?
Thank you, Your Honor. So this is Mallard Street in Lansing. We had a hearing in court on June 13th of 2023. During that hearing, the court received testimony from the plaintiff, Mr. Meyer, and the defendant, Mrs. Arambula. And it also received several exhibits into evidence, including Plaintiff's Exhibit 1, a copy of a land contract dated October 15th, reflecting a monthly payment of $1,050 a month. Exhibit 2, a complete payment history on the land contract. Exhibit 3, an expected amortization at the rate of $1,050 per month. And finally, Exhibit 4, a City of Lansing trash removal assessment. And from the defendant, this court received an identical copy of the land contract, but reflecting a lower payment amount of $681 per month. After receiving the testimony and evidence in this case, the court held that the plaintiff failed to satisfy his burden. And the plaintiff does now move to set aside the judgment and for entry of a new judgment or in the alternative, a new trial pursuant to MCR 2.611 subsection A. Now, upon filing of such a motion, this court may set aside the judgment if one has been entered, which it has. B, take additional testimony. C, amend findings of fact and conclusions of law. Or D, make new findings of fact, conclusions, and direct the entry of a new judgment. Now, such relief is proper on all or some of the issues whenever the substantial rights of a party are materially affected as a result of a verdict or decision against the great weight of evidence or contrary to law. The standard in civil cases is preponderance of the evidence, and the Court of Appeals has held that a court's decision is against the great weight of evidence where the evidence clearly preponderates in the opposite direction. Now, Your Honor, during the testimony and based on the exhibits in this case, it is undisputed, as it was undisputed at trial, that a land contract was entered into between the plaintiff and the defendants on or around October 15th of 2020. Now, this court was presented with a factual issue, which version of the contract controlled. Was it the copy that had $1,050 per month or the copy that had $681 per month? It seems as though the court resolved that question in favor of the defendants, which the plaintiff does not challenge or seek to set aside today. And where this motion is filed based on the premise that the $681 contract offered by the defendants and the defendant's only exhibit entered at trial does control in this case. Pursuant to that contract, the defendants agreed to purchase the property for $80,000 per month. They agreed to make monthly payments of principal and interest of $681 per month. And the plaintiff agreed to apply those payments first to accrued interest and then to the principal balance. And plaintiff's exhibit 2 that was admitted at trial is a payment history. Mr. Meyer testified that that accurately reflected each and every payment made. And there was absolutely no testimony from the defendants refuting that payment history. Now, based on that payment history, the plaintiff did in fact apply each of the defendant's payments first to accrued interest and then to the principal balance, including if they made an overpayment. That payment history reflects application to interest and then a subsequent reduction in the principal balance. That payment history further reflects that since July 1st of 2022, the defendants have only made 2 payments, $731 paid on July 9th of 2022 and $681 paid on December 15th of 2022. So between the months of July of 2022 through May of 2023, the defendants missed 9 monthly installment payments. Now, those facts that I set out were largely uncontested at trial. The only true issue this court had to resolve was a factual issue this court had to resolve was which version of the land contract applies. However, ultimately, the court held that the plaintiff failed to meet its burden, and the plaintiff alleges that that conclusion was against the great weight of the evidence. The court did address several other issues in its holding. One of those issues was the fact that both versions of the land contract, the plaintiff's signature was notarized by plaintiff's spouse. And of course, that under Michigan law is a invalid notarial act. However, as I outlined in the plaintiff's brief, that does not, under Michigan law, both statutory and case law, does not invalidate the underlying document. So based on the largely undisputed facts, I would assert the plaintiff did establish his burden at trial. Number one, he established the existence of a land contract. Number two, he established that the defendants were 9 months delinquent on that land contract based on the payment history. And so there is sufficient evidence in the record for this court to set aside the existing judgment and enter a new judgment under MCR 2.611 A2B. And the plaintiff's position is there is already sufficient evidence to find that there is an arrearage of $6,129, and that is simply $681 per month times 9 months of unmade payments between July 1st of 2022 and the date of our hearing in June 13th of 2023. Plus other damages of $610, which the court did award at the hearing for the trash removal assessment, plus the plaintiff's costs of $243.68. So there is sufficient evidence of those figures to enter a judgment with a total redemptive amount of $6,982.68, payable within 90 days, because less than 50% of the land contract balance has been paid. And further, for entry of a money judgment of $610, as the court originally did, arising out of that trash assessment.
Give me the total arrears for the non-payment For the 9 months again, 6,000.
Yes, 6,129.
Any additional argument?
No, I don't believe so, Your Honor.
Okay, Mr. or Mrs. Arambula, you can respond.
Yes. Well, I guess first thing, is Mr. Stanley Meyer here?
No, he doesn't need to be here.
He does not?
He's
Okay.
He's an attorney.
Okay, thank you. That was just my first question.
You can respond, though.
Okay, yes. So I guess the first issue at hand was the fact of which contract were we following? I was following my contract since 2020. And our previous hearing, I would say, rectified which contract we were going to follow, which is the 681. So at this point, paying the 681 has never been an issue to be paid. The issue that we are having currently is, where is this money going? How is this money being paid to the mortgage, the interest, and the principal? One thing discussed at the previous hearing was that I have been requesting, at least for the past 14 months now, documentation as to where the monthly payments have been going. The first time I actually received where the documents were going was this, was the motion that I just received in the mail about 2 weeks ago. That is exhibit 3 and 4. Within the 14 months, that is the first time I've seen any breakdown of where my payments are going. I have been consulting with legal counsel and am looking to move forward regarding my contract, and the fact that if Mr. Meyer was following his contract with a 1050, that means he was paying a different price for the payment of the mortgage, the interest, and the principal. So if he was following his contract at 1050, he was within breach of contract of my current contract, the 681. So still, at the end of the day, a breakdown of where this money is actually going has been needed, has been requested, and all I have been provided with is more court dates, or Mr. Meyer trying to either evict me or, you know, request a repayment of the missed 681.
Okay, well, the issue I need you to respond to, because you didn't file a counterclaim in this for what you're alleging now. So you obviously have the right to make your claim against Mr. Meyer or Mrs. Meyer outside of this for whatever you're claiming. And it looks like you have at this point gotten some documents to support where the money is being applied or being held. But what I want you specifically to respond to is, the court did make a ruling at the last court date as to which contractual amount is going to control. And the court sided with you for the reasons that the plaintiff never provided a appropriate witness. Mr. Meyer was not present when the agreement was executed. You can't be the only witness you call. You need the person who was actually there, and Mr. Meyer stated on the record he had no knowledge of any changes to the contract. And then the person who was there during the execution was also the person who was later the notary. That person was never called conveniently to court. And so that was the part, or largely, why the court believed or ruled in favor of the defendant as it relates to which contract is going to control. In addition to that, the defendants provided a clean copy. It didn't appear on its face to be anything that was altered or changed in any way. And so now the question you need to answer is, they stated, based on my ruling, which is that amount in the contract that you provided the court is going to control, that you still miss 9 months of payments. Did you miss 9 months of payments?
I missed, hold on, let me look at the dates, because every time I made a payment, that's when I received another action with the court. So every time I made the 681 payment, so I made a payment in June 2022. I received court documents saying that they were going to forfeiture the home. I made another payment 2 weeks later, and then that's where I was provided with a signed copy stating we were going to have a court date in October. So when that case was
I just
dismissed,
need you to calculate and let me know if you're disputing the 9 months.
yes, it is now 9 months. Now it is 9 months. There has been payments made in between that 9 months. It wasn't 9 months consistently, but yes, we are now at
Yeah,
the
it doesn't
point
have to be
of 9 months.
consistent. Do you owe 9 months worth of payments?
Yes, I do.
Okay, judgment is granted in the amount of $6,129 plus court costs. And the judgment that was already ordered, which was for 610 for the amount of the trash removal, I believe it was.
Yes, Your Honor.
Yes,
Okay.
you're correct.
For a total of $6,982.68 to be paid within, there's a 90-day redemption period, that is. And so the money judgment will stand for the amount of $610. Did you have an order?
I don't. I will submit one under the 7-day rule, Your Honor.
Okay, order will be submitted under the 7-day rule, and then some of the things that you're sharing, it sounds like you're getting legal counsel. If you pursue that, that's separate from this case, okay, ma'am?
Yes.
Okay, any additional matters for the record?
Nothing for the plaintiff, Your Honor.
Okay, you're all set, thank you.
Thank you, Judge.
Thank you.
You're welcome. Okay, back on the record in the matter of Lasky versus Middlebrook. Do the parties complete their discussion?
We did
Yeah.
not, Your Honor. Reached a bit of an impasse. The testimony at the beginning of the discussion, if you will, or the answering to the questions regarding employment, revenue, income was that unemployed and hasn't been employed since her salon shut down in 2022. Further questioning, in answer to further questioning, she indicated that, how's your rent getting paid then? She said there was an individual who was paying her rent. I asked for the name of the individual and she wasn't going to provide that to me. Rather than moving forward, I stopped the examination to get some clarification from the court because the defendant was uncomfortable releasing that information to me. I think it's perfectly relevant. This is a creditor examination. She has regular monthly bills. Her testimony is that there's a gentleman paying those, but I know from information my client has sent me, her online postings. She has a number of different other sources of income that I'll get to later in the examination, but rather than continuing, I was hoping for some direction as to whether or not she needs to divulge the name of the person who is paying the rent at her current residence.
Okay. The person who's paying the rent is the spouse?
No, we're not married.
I don't know.
It's a boyfriend of mine, but like
Okay,
I
she
told
said
him,
they're not married, it's a boyfriend. I don't know that I would require her to provide a boyfriend's name.
Who is,
under
her
a
last,
creditor's exam.
you bet. Her last name is Middlebrook, correct?
Correct.
Okay. Who is Jan Middlebrook? Is that a family relation?
She said that's her mother.
That's her mother. Does the mother live, the residence she gave me was 2405 East Jolly, Lansing, Michigan. Correct, Miss Middlebrook? That's where you reside?
Correct,
Okay. Does Jan Middlebrook live there with you?
correct.
Okay. And she's a registered agent of a company called BAC Safe LLC, correct?
Okay.
No, is
Is
that
that
correct?
yes?
Yes,
Okay. And BAC Safe LLC is a company that you are currently involved with and have been marketing online, looking for customers. I believe it's some type of ignition interlock system. Is that correct?
it's incorrect. So I have not been looking for customers yet. If you're referring to my Facebook page, if you take a look at the date that I posted that, I said I can't wait to share with you guys what I have been working on for several months. So, correct?
All right.
So
I
I
think
have not officially started the business per se. So I made a Facebook status that said I can't wait to share with you guys what I have been working on. Does not mean that I have generated any revenue or anything in that matter. You asked me about hair in the film department, and I told you that I did work on a movie 2 years ago and one 3 years ago. That doesn't mean that I'm actively being paid for that at the current moment. So I said that I'm unemployed. So as far as me marketing my hair services, the last time that I have physically marketed a hair service was back in February of this year. So if you're looking at my Facebook, then that's what you're referring to. You asked me if I worked at a podcast. I told you that every Thursday from 12 to 12:30, I go on a gospel station, 1440 WMKM, and I go there every Thursday. I'm not being paid for that. I go up there and we talk about things that are going on in the community. So I was completely honest with you with my answers. You decided to end the conversation and I was fine, but I was honest with you with my answers.
just so that we're clear, since the beginning of this year, you are unemployed and have no income, correct?
Correct.
All right. The LOC class that you taught, I believe it was May 8th. It had something to do with
Well, can I-
grading. It was a hair class.
Can you all return to the privacy now? Because it sounds like the
Yeah.
only issue was whether or not she should provide the name of the boyfriend. I don't think she needs to provide the boyfriend's name. He wouldn't be subject to any garnishment. It's not her husband. And so I'll let you go back because it's not, a lot of this stuff should be personal to the best that it can be. If it becomes troublesome, then we can come back on the record.
That's fine. It's just as a point of clarification, on a motion for supplementary proceedings to depose an individual who's providing monies to a debtor, has this court historically allowed depositions to proceed as far as a supplementary proceeding against an individual like the boyfriend who's apparently paying her rent?
Well, I don't know, because I wasn't in the room, if she's saying that he's paying her rent or that she's living with him. I'm not, there's a difference there too. So if you determine that she's receiving funds from somewhere, that's different, and then we can proceed that way. But if it's that she's living with someone, I'm not gonna order or allow us a subpoena to depose that person just because she's living with them.
That makes sense. Thanks for the clarification, Your Honor.
No problem. You can go back on the Zoom, and if you need help, he can help you.
Okay.
Okay, there was somebody, Mr. Hepnar was here for something. Mr. Hepnar, which matter are you here on behalf of Farm Bureau versus Ivantez Adams and Shonda Mitchell?
I am, and good afternoon, Judge.
I don't think we've seen either of them, but let's double check.
Just so you know, Judge, Adams is in default and the judgment's been entered, so I doubt he's going to show up.
Okay, not signed by defendant on. Okay, sounds good. Party has failed to appear, and how did you want to proceed?
Judge, I guess my request would be to enter now a default judgment against Defendant Mitchell. You may recall the last time that I was before you, you set the pretrial for a live appearance. I appeared, she did not. Apparently, there was an issue with a medical emergency with a family member, according to her. And I hand delivered all the joint pretrial statement that had all my contributions toward it, sent it to her the very next day or that same day with an instruction that this case was going to be set for a rehearing today. She hasn't appeared a second time. I would ask that the court enter a default judgment.
Default judgment is entered in favor of plaintiff. Let's see, what is this?
It's a sum certain, Your Honor, as well. It pled in the complaint. The only thing that's not in there would be the taxable costs. If you want me to submit an order today, I'm happy to do that.
Yes, if you can submit an order. Who's in the waiting room? Let's see. Give me just a moment. Someone is in the waiting room. What's your name? Hello, sir. What is your name?
Byron Ben.
Okay, I don't see him on here. Okay, so Mr. Hypnar, you can submit an order to the court and I'll sign it.
Thank you, Judge. Just so you know, the amount prayed for in the complaint is $5,285.45. And that's what I will be completing the judgment for, as well as the taxable costs consisting of the filing fee and the service fee.
Thank you.
Judge, can I email that to your clerk?
You can send it to Judge Simmons Courtroom at lansingmi.gov.
Very good, Judge. Have a wonderful afternoon. I appreciate it.
Same to you. Okay, Mr. Do we need his last name spelling? Do you have a case number? Sir?
Are you talking to me, Judge?
Absolutely. Yes. Do you have a case number? His bandwidth is low, it says.
I'm sorry. I'm currently in Indiana right now.
Okay, what's your last name?
Ben.
Spell it, please.
BENN.
You have a landlord tenant hearing tomorrow at 3:30?
I thought it was the 18th.
It's tomorrow is your court date, and wherever you are now, looks like you're in a car and you have low bandwidth. You can't be there because it doesn't work for court. You need to be
Okay.
someplace where you can get a good signal, okay?
Okay. So tomorrow at 3:30?
That's correct.
Okay, thank you.
You're welcome. What was that? Okay, on the record in the matter of Joseph Vitale versus Chrissy Petey, file number 22-04155 LT. Here for the record.
Continue more for the plaintiff, Joseph Vitale.
And then we have Ms. Petey here representing without counsel today, correct?
All right.
Okay, today was the date and time that we set this matter for a hearing. Let's see. You wanted to provide some evidence to support some conditions of the property.
Yes, there's numerous things. I'm also in the process of obtaining legal counsel with Barry Law, Attorney Ron, but he will not be back in town till Friday. So
What is, when you say you're in the process, what does that mean?
I've spoken with him and he's agreed to take on my case once I pay the retainer fee, but he can't do anything until he gets back into town.
Okay. And when do you plan to pay the retainer fee?
As soon as he gets back into town. What you said was Friday.
Okay. And did you speak with his counsel today?
I did, Your Honor.
Okay. And why would you speak with counsel if you're gonna hire an attorney?
Well, I told him I wasn't going to say anything.
Oh, okay, that's, got it. Okay.
Yeah.
Okay. Counsel, did you file an appearance?
I did, Your Honor. I dropped off the clerk's office with the judge's copy, and I apologize if it didn't make it up here to you.
Oh, no, I know you're probably fresh on the case, so.
I was retained last week, yes.
Okay, sounds good. She entered it today. Okay, that's why. They entered it today.
Yes.
Okay. Sounds good.
And to the extent that we had some conversations, we did extend an offer, couldn't reach a resolution. She did indicate to me that she's planning on retaining an attorney. To that extent, we did have some communications, but I'd be inclined to allow Mr. Bari to get familiar with the case, but I'd ask that you only reschedule it for maybe a week or 2 weeks.
Well, yeah, I need to make sure that he's gonna be able to appear. And
Correct.
then obviously, if his schedule, he's gonna need to get up to speed, but he's gotta come to court or at least file an appearance to show he's on the case.
And just for the record, Your Honor, I'd submit that this case has been ongoing since December, and she's had ample opportunity to hire an attorney. They have engaged in the court proceedings since that date. And so
I agree.
I think I would submit that this is a delay, another delay tactic, but to the extent that you're willing to allow her to seek counsel, I'll just put an objection on the record.
Thank you. This is the first that I've heard of is her actually speaking to an attorney other than legal services, that is. She was advised of her rights, however, on the first court date in this file, which was in February. You were advised of your rights to be represented by counsel. You were given an opportunity, because that was a pretrial, to seek counsel before your next court date, which wasn't until April. Why didn't you seek counsel?
Your Honor, I tried to get legal aid's help. I went back and forth with them for like a month and a half. And one attorney that I spoke with about legal aid said he was going to help me. And then I had the office call me back around 3 weeks later saying that they were unable to take on my case due to the type of situation it is. I then called back legal aid. It was around June. It was the end of June. It was around June 20th, I believe, or 21st. And I spoke to an attorney. He gave me some advice and that was it, but they said they could not help me any further than giving me a little bit of advice. I was not planning on hiring an attorney, an actual attorney, until just recently because of new things that are happening with this case.
Okay. To the extent that this is another delay tactic, it likely could be, because I am not gonna lie, I thought that you played some games with the court schedule.
No, Your Honor.
There's been multiple times, I think we got a request to a delay yesterday, which I denied.
Yes, Your Honor.
And then there was a time when you called and you said you couldn't speak. So you had something going on with your throat or something, and so you needed an adjournment. Then you were in the hospital. The only reason why I have to give her the benefit of the doubt is because the things that she's alleging could likely cause some of the issues that she's now saying that are keeping her from coming to court. She's claiming she's having health issues. I've seen some pictures. I don't know if they showed you these pictures, but they should be providing you that if she's going to proceed with the hearing. And so because of that, I'll give you a 1-week adjournment to the extent we can put you on next week. So that, is it Mr. Barr? You said?
Ron, yes.
Ron Barr?
I think it's Bari, Your Honor.
Bari.
Barry, okay.
Bahrie.
Yeah.
Yeah. I'm familiar with Mr. Bari.
Got it. I think I am, so I've seen his signs everywhere. Okay.
July 26th.
July 26th?
2:30.
At 2:30. Yes, ma'am.
Okay, so, the main reason why I'm saying I do not owe Joseph rent is because.
Well, if you're gonna hire an attorney, you need to let your attorney come in and make those arguments. We're giving you an
Okay.
adjournment, okay?
All right, I do want to say though, Your Honor, the reason why I'm hiring an attorney is because I have been trying to get all my items appraised and someone to come in and kind of give me an estimate on what I've lost is worth. Nobody but ServPro is willing to help, and they have quoted me almost $15,000 just to come in and remove the mold, dehumidify the basement, and they have to go piece by piece individually of everything in the basement. And then they have to professionally clean it, which nothing in there is salvageable anyway, so. And I do have their service report that they gave me, their report, ServPro's report, an estimate of what it's gonna cost to get rid of every item in the basement, and that's not including everything else in the house.
Oh.
And they cannot do anything now because there's asbestos in the basement. And a lot of asbestos. It's the whole boot of the furnace is wrapped in asbestos, and the top of the furnace also has asbestos, and ServPro will not even come and attempt to do anything until the asbestos is removed.
Okay, so we'll let you hire your attorney, and he should be here next week for your court date, July 26th at 2:30. That works for you, counsel?
I'll be available, Your Honor.
Okay, any additional matters today?
No.
Yes, Your Honor. To the extent that you previously denied the improper plaintiff's motion for escrowing rent pending the proceeding, I'd renew that motion in front of you today to have them at least place some good faith money into escrow. They haven't paid rent since October. I understand there's some occupancy issues that they're claiming, but it still doesn't relieve them of their obligations under the rent. And I know you've denied the motion before, but I'd respectfully renew that motion today. I think it's reasonable and within the court rules and the statutes.
Okay, you're requesting escrow for how many months, right?
Well, I'd request escrow back from October, but I understand that's probably an unreasonable request here for the month of July at least, Your Honor.
I'll grant that amount.
Okay, and that would be in the amount of $1,795.
That needs to be escrowed at court. Okay, so escrow order to issue in the amount of $1,795 for July's rent to be entered here at the court and each month thereafter.
And I would request that July month be escrowed before the next hearing date, Your Honor.
Okay. Do we have I don't know if we have an escrow order on printed. We have printed an escrow order for you.
I apologize, I should have brought one.
No worries. We can print you an escrow order for you to complete and I'll sign it. It'll indicate that the defendant needs to escrow 1 month's rent before the next court date. That's the amount of $1,795.
Yes, Your Honor.
Any additional matters?
Not from the plaintiff.
Okay, and it needs to be escrowed here at the court. Okay, we'll get you your next court date.
Thank you.
Thank you. Miss Mitchell is late.
Yes, ma'am.
He's not, he was not. Feel free to go. Miss Mitchell, you're supposed to be here at 2:30.
I understand. I just got the notice about 20 minutes ago.
You got what notice 20 minutes ago?
This one?
That's just a Zoom instruction. Where's your notice?
Right here.
Okay. You're saying you just got that in the mail?
I didn't just get it in the mail. I just got it from my house like 20 minutes ago.
Oh, okay. Well, that's a personal problem because you knew you had a court date and the attorney appeared and we waited and you
Okay.
didn't come.
Okay.
And you also didn't submit a response to their motion.
I don't, because I don't have any knowledge of any of this. So my thing was come out here and just whatever he's asking for, go ahead and give it to him. I'm just gonna file for a bankruptcy.
Okay, well, he's gonna submit an order and then you can file for your bankruptcy if that's what you choose to do. Once that happens, then the court should be notified so that an administrative order can be put in the file.
Okay.
Okay, you're all set.
Thank you.
Okay, and Mr. Smith and Ms. Middlebrook, are you all set for today?
Ms. Middlebrook wanted to come back to the courtroom.
Okay, we're back on the record.
Do I need to explain everything?
Well, what was the issue?
Well, I was explaining to Mr. Smith that originally when me and him spoke, we set up payment arrangements of $150 a month. As he stated, maybe I didn't read the whole letter entirety, and I said maybe that is accurate. So what I explained to him is once we had set up payment arrangements, we also had an additional court date to come back to. I came back to that court date. He did not show up. I had all proof and everything that I was supposed to bring with me there. What happened was I filed my taxes in February of that same year. Once we had made payment arrangements, my taxes ended up getting taken, my state, and they were applied to LiveQ. So what I did is I did not make a payment because to my understanding, we had set up a payment arrangement. I just was explaining this to him. I did not know that they were also going to take my taxes. So since they did, I didn't commit to the payment arrangements. So I said, okay, I can take that. I understand. Maybe I didn't read the entire of it. He said at the bottom of the paperwork, it did say that they could still garnish my taxable income or whatnot. I didn't see that. So at this point, like I told him, if he's willing to go into another payment arrangement, I will do that. But as far as me having to give him the names of anybody who I'm associated with, if my phone is in somebody else's name, if I'm not willing to go down my whole background and history, a sexual partner, a cousin, a brother, or all of that, that is nobody's nobody else's business but mine. So at this point, if he wants to go into a payment arrangement, I will do that. But I am not willing to sit here and go through my entire background. As I stated to him, I was truthful. He knows that I do have LLCs. He knows that I do own a hair salon. My hair salon is closed down. So if I do wish to work here and there, but I'm physically unemployed at the present moment. So I'm willing to do a payment arrangement, but I'm not willing to go through my complete background.
Mr. Smith?
The issue with the last creditor exam that she's referring to the payment plan arrangements that we put together, the payment plan letter that we sent out, we did agree to $150 a month. There were a number of documents that were responsive to your subpoenas she had to produce. And most importantly to LAFCO was the tax filings, the last 2 years of tax filings. And it was important to LAFCO because she gets a significant state income tax return, which would indicate significant income, whether it's 1099 or W-2. LAFCO is very aware of a lot of different business entities, revenue streams that she's involved with. The hitch was when I sent the payment plan letter out, it also reminded her, here are the documents that you are required to produce under the subpoena. None of them were produced. And I am more than willing to discuss moving forward a payment plan arrangement with the defendant, but we're not LAFCO will not negotiate in a vacuum. She did not produce.
She did appear back on May 18th. I don't know if she brought, I can't say one way or the other if she didn't appear, but she did, if she brought documents, but she appeared. I would assume that because we reset this in March for her to appear with documents in 30 days, she appeared. My note said plaintiff failed to appear that day.
And then she and I spoke and I said, get me the documents that you were supposed to produce and then we can cancel the next date. As I'm sitting here today, I have no documents. I don't have bank records. I don't have
she's saying no, she didn't speak to you after. Wait a minute. She's saying no, she didn't speak to you after that. My note in the file says on April 18th, plaintiff failed to appear. And she stated to the court, because this is my record here, that 1901 was garnished from her taxes. She stated at that date that she was upset about it.
There
And
wa-
so to the
Correct.
extent that she misunderstood that to be a portion of her agreement, I think that's evident just to the extent that she brought it up when she appeared with the documents. And then I think it was reset in August but that's when she didn't appear in August. So you requested a bench warrant. So why don't we try to get these documents that were
That would
supposed to
be
be provided last
exactly.
year?
Exactly. That's exactly what I need. And once I have those documents, then I can have a meaningful discussion with her about her ability to pay and what type of monthly payment plan would be appropriate. But I can't do it without
So
the
whatever
documents.
those documents were, are you able to provide those to him?
Yes.
Okay, so she says she can provide you those documents. I can reset that so that you all can exchange those documents.
And if we could do this, we can reset this, and then Miss Middlebrook, when you get those in the mail to my PO box, just get put your cell phone number. Actually, I think I have it from the last phone call, the cell phone with for Deonta Morris. Once I have those documents, if it's okay with you, I will reach out if you're comfortable with that. If I have questions about those documents, we can have a conversation, perhaps even set up a monthly payment plan, which might then negate the need for us to appear back in front of Judge Simmons again.
That is no problem at all.
Okay, you have my address, you've got my phone number. I'll send you another letter today reminding you here are all of the different documents we need that are responsive to that subpoena. Okay?
That
All right, I think that's a good approach, Your Honor.
I'm gonna give you a control date.
August 22nd.
At 2. August 22nd at 2.
All right, that sounds good. Thank you, Your Honor.
Thank you. We'll get you a copy of the notice. You'll be all set.
Okay, thank you.
Appreciate it.
No problem. Thank you.